In discussing arbitration, we want to talk about the types of arbitration. And so we talk about interest arbitration and we talk about rights arbitration or grievance arbitration. Essentially, there are two types, so what are the differences between them? We want to deal a little bit about the history and the legal state of arbitration. We want to talk about the arbitration of statutory rights in union and non-union cases, right? So essentially what we're saying there is what happens if an employee has a right to eliminate age discrimination, or they have a right to be safe with respect to age discrimination, but yet they have a union contract that either calls for arbitration or doesn't. So how does their statutory or legal right with respect to something like that compare to what their union contract says? We want to talk about the steps in selecting the arbitrator. We wanted to talk about determining arbitratability, and so what are the types of issues that would go to an arbitrator. We want to review some of the hearing procedures. And so once a case gets to the state that it's going to be heard by an arbitrator, we want to talk about some of the case preparation processes. We want to cover a little bit on the idea of just cause, which really is a vague concept in labor relations. But when is there sufficient or proper reason for which management has the right to discipline or discharge employees? And then, as we've done in prior chapters, we want to talk about how arbitration impacts the public sector. You'll recall that in all of our previous discussions on key points, we talked about the private sector first, but we finished up with the impacts and the how that issue relates to the public sector. And so when we talk about the idea of arbitration, we're really talking about how to resolve an issue, right? And this issue has gone through likely through numerous rounds of negotiation. It's been discussed between management and the labor group, and we're not able to get to some level of agreement on it. And as is generally called for in many collective bargaining agreements, then this issue goes to arbitration. So arbitration is the process in which the parties involved agree to submit an unresolved dispute to a neutral third party whose decision is final and binding. And so the important point to note here is that unlike mediation, once a process or a dispute gets to the arbitration process, we are bound by the decision of the arbitrator. And keep in mind that both the labor party and management have a voice in determining who the arbitrator is, and these are as we noted, neutral, unbiased third parties. And so we talked earlier that there were two major types of arbitration with respect to labor disputes: interest arbitration and rights arbitration. Interest arbitration is this process that's used to resolve an impasse in negotiations in which the parties submit the unresolved items to a neutral third party to render a binding decision. So interest arbitration resolves conflicts of interest over the establishment of the terms and conditions of employment that are negotiated through collective bargaining and formalized in union contracts. A breakdown of these collective bargaining negotiations could result in strikes. Interest arbitration avoids or ends strikes. So interest arbitration is compared to rights arbitration or grievance arbitration, which really involves interpretation of a party's rights or the application of a particular provision under an existing contract. Rights arbitration is found in almost every labor agreement and used far more than interest arbitration. This idea of grievance arbitration became popular during World War II when most unions had adopted a no-strike pledge. The War Labor Board, which attempted to mediate disputes over contract terms, pressured for inclusion of grievance arbitration in CBAs. The Supreme Court subsequently made labor arbitration a key aspect of federal labor policy. And so rights arbitration deals with the allegation that an existing collective bargaining agreement has been violated or misinterpreted. Most collective bargaining agreements set out a procedure for handling of disputes and differences. And so we want to keep in mind that interest arbitration is generally engaged in order to prevent or end strikes. Rights arbitration is generally engaged in the interpretation of contract, and that's why we call it rights or contract obligation, are engaged in the interpretation of the current collective bargaining agreement terms and conditions, the interpretation of those and or the application of them. There are no prescribed rules for grievance or rights arbitration, such as in the judicial process. The arbitration procedure should be based on the wishes and the needs of the parties involved to the extent possible within the judgment of the arbitrator. In general, when we're talking about rights arbitration, the arbitration process is more private and therefore more unique to the parties as compared with the public judicial process. The grievance arbitration procedure involves more sophisticated and knowledgeable parties than those in most judicial procedures, and in the arbitrator in most cases is more knowledgeable than the judge. And so here we're just looking at a few of the factors that we want to consider when we're considering arbitrating a grievance. And so we talk about the ideas like the importance of the issue. Is this something that's really very minor, or is it a very important issue that may have implications well beyond the current case? What would the effect of winning be? And that could be the effect of winning on management or the effect of winning for the union. What would be the effect of losing? What are the possibilities for a settlement? Do we really still need to go to arbitration, or is there still some glimmer that a settlement could be reached? There are the psychology or face-saving aspects, and obviously this becomes important. We talked earlier with respect to negotiating the collective bargaining agreement, and in as much as something that's gone to arbitration is a reflection of the meeting of the minds as a result of that negotiation process, we need to take into account whether there's any psychological or face-saving aspects with respect to that. And then what are the merits of the case? If we take this to arbitration, do we have a strong case, whether we're the labor union or management, which relates a lot to this idea of the psychology or face-saving aspects, right? If we don't have a strong case and we lose because we don't have a strong case, then it may appear as though we were weak in our ability to stand up to either management by the union or to union by the management. So there are a lot of different issues and different perspectives that we need to take into account, whether we're the union or management, when we're looking at arbitrating a grievance. There are a couple of landmark cases that we talk about with respect to the history and the legal state of arbitration. One of them is the Lincoln Mills case, and this required specific performance of an employer's promise to arbitrate in a collective bargaining agreement. The court felt that the agreement to arbitrate grievance disputes was the employer's trade-off for the union's agreement not to strike. The role of arbitration in court enforcement of contract agreements was more specifically outlined in 3 Supreme Court cases known as the Steelworkers Trilogy. These cases held that the function of a court is limited to a review of whether the issue to be arbitrated is governed by the contract. Any doubt as to the coverage should be resolved in favor of arbitration. Three important issues have evolved from the Lincoln Mills and the Steelworkers Trilogy cases. Those are the principle of general arbitrability, situations in which the contract has expired or the ownership of the company has changed, and whether the duty to arbitrate survives a change in company ownership. With respect to general arbitrability, the courts have consistently enforced the principle that if the contract provides for the arbitration of grievances, then a grievance is presumed to be arbitrable as long as the agreement does not exclude the topic under consideration. With respect to expired contracts or changes in ownership, the U.S. Supreme Court has ruled that the duty to arbitrate can extend beyond the life of a contract. A post-expiration grievance is arbitrable only when it involves facts and events that occurred before the expiration of the CPA, when the action infringes a right vested under the agreement, or when the normal principles of contract interpretation show that the disputed contractual right survives the remainder of the agreement. And then, with respect to successorship, the Supreme Court has also ruled that a successor employer is not required to adopt the substantive terms of the predecessor agreement, but that the successor inherits the contractual duty to arbitrate as long as there is a substantial continuity between the old and new companies. And so in summary, the rulings by the Supreme Court on the duty to arbitrate have made it clear that if the parties' labor agreement requires the arbitration of grievances, then it's going to be difficult to avoid arbitration. Even where the CBA has expired, a new owner becomes the employer or successor, or the issue is not explicitly discussed in the CBA. The arbitrator's role, however, is not unlimited. Starting with the Steelworkers Trilogy, the Supreme Court limited the arbitrator's role to the interpretation and application of the CBA. The court held that although an arbitrator may look outside the contract for guidance, he does not sit to dispense his own brand of industrial justice. The court stressed that the arbitrator's decisions, as long as they are based on an interpretation of the contract, should be final and binding and not questioned by the courts. And so in Alexander and Gardner Denver, the Supreme Court addressed the application of an arbitration clause to the pursuit of an individual's statutory rights, even if the individual is covered by an arbitration provision in a CBA. In that case, the court ruled that an individual could not be precluded from suing under the civil rights laws just because his claim had gone through arbitration under the collective bargaining agreement. The court was articulating a public policy exception to labor arbitration provisions. And so, as you may recall, Title VII prohibits discrimination under various protected cases, gender, race, right? And in this case, we're talking about the grievant who loses an EEO matter in arbitration is entitled to take the matter to court. And this becomes apparent in the Wright versus Universal Maritime Service Court decision. And in this decision, a longshoreman was refused employment following the settlement of a claim for permanent disability. He then filed suit under the ADA, or Americans with Disability Act, and the lower court dismissed the case because the longshoreman failed to pursue his claim under the contract's arbitration procedure. The Supreme Court reversed the lower court decision on the grounds that the arbitration provision did not contain a clear and unmistakable waiver of the employee's right to pursue his anti-discrimination claim in federal court, and at least one federal court has ruled that a waiver of an individual's statutory right by a collective bargaining agreement is non-negotiable, making it an illegal bargaining item. And so we have this issue again when we talk about these statutory rights. Title VII is a statutory right that's passed on to employees by law, and the issue becomes one of whether, if an employee either decides not to arbitrate for a Title VII offense, can they litigate it in court, or if they do arbitrate, are they able to litigate it in court subsequent to a loss under the arbitration procedures. And so in the United States, 3 statutes govern the private sector arbitration of disputes. The 1947 Labor Management Relations Act, which provides for the arbitration of disputes involving CBAs. The 1926 Railway Labor Act, which has jurisdiction over disputes between employees and carriers of the railway and airline industries, and the 1925 Federal Arbitration Act, which is also called the United States Arbitration Act, or the FAA. And so the FAA governs commercial arbitration situations such as business-to-business, employer-to-employee, and buyer-to-seller situations. The FAA provides that parties involved with guidelines and enforcement mechanisms for arbitration disputes. The Act enables one party to force the other party to arbitrate a dispute when an agreement to arbitrate exists between the 2 parties. And it also provides that an arbitration award can be confirmed by a court judgment. So in the Circuit City Stores versus Adams case, the employee had signed an employment application with Circuit City that included a provision agreeing to settle any and all claims, disputes, or controversies arising out of or relating to employment exclusively by final and binding arbitration. By way of example only, such claims include claims under federal, state, and local statutory or common law, including the Civil Rights Act. So we see here that the employee had signed away their rights to litigate beyond arbitration. Even those acts that were, or those violations that might have been considered violations under the Civil Acts right or other federal, state, or local common law. 2 years later, the employee filed an employment discrimination lawsuit against Circuit City, and Circuit City filed a suit to require him to submit to final and binding arbitration. The Court of Appeals ruled that because the FAA excluded coverage of contracts of employment of seamen, railway workers, or other class of workers engaged in foreign or interstate commerce, the clause was not enforceable. The Supreme Court disagreed, however. It held that the exclusion language of the FAA ought to be narrowly interpreted to apply only to transportation workers. And so in Greentree, the plaintiff claimed that because the arbitration clause in the CBA was silent about the cost for such arbitration, she was effectively precluded from pursuing her statutory claim under the Truth in Lending Act for fear of incurring excessive costs. The court ruled that a party seeking to avoid an arbitration agreement must demonstrate the likelihood of incurring prohibitive costs, not just the possibility. And then in February of 2008, the Supreme Court held that a challenge to the validity or legality of a contract that has as an arbitration clause must be decided by the arbitrator, not another state or agency, because the FAA has preempted state laws in this area. And so now we finished with some of the history and statutory or legislative and court decisions around the arbitration process. Let's talk a little bit now about selecting the arbitrator. So both management and labor pay the arbitration fees, and so they both have a hand in selecting the arbitrator. He's not just an outside party imposed on them to resolve disputes. The arbitrator's judgment evolves from the contract negotiated by the two parties. Therefore, the arbitrator's performance must generally be satisfactory. The parties can dispense with an incompetent arbitrator. The arbitrator is well aware that he or she provides a service for a fee and is expected to meet certain professional standards. However, and unlike litigation, most parties have the ability to participate in the selection of the arbitrator. This is recognized as a great advantage over the litigation process, in which the parties have little or no input in the selection of a judge. In fact, both parties can easily access thousands of arbitration awards by arbitrator, by employer, and by union or subject matter, so they know a great deal about possible arbitrator candidates and their thoughts on similar matters. And so you can select an arbitrator either on an ad hoc basis, that is, as issues arise, or they can be selected prior to any issues coming up at the time the CBA is negotiated to serve as we call here the permanent umpire, so they really resolve disputes for the life of a contract. And so either scenario is possible in selecting an arbitrator. And so where we go in order to be provided a pool of arbitrators is either the Federal Mediation and Conciliation Service or the American Arbitration Association, and these agencies are the most frequent sources of arbitrators. So here we see the steps in selecting the arbitrator. So step one is that the parties, that is management and labor relations, are provided a list of proposed arbitrators. These parties are then given 7 days to study the list and cross off the names and then rank the remaining names, or cross off the unacceptable names and rank the remaining names. There may be that the remaining names between both parties cannot be agreed upon, so additional names are submitted. Still, again, with the outcome of this being that we want to determine an arbitrator acceptable to both labor and to management. And then if parties cannot agree on an acceptable mutual name, then there will be a National Labor Relations Board tribunal which will make an administrative appointment. With respect to the role of the arbitrator is required to follow the contract language regardless of any personal opinion as to the reasonableness of the agreement language if the intent of the provision is clear. However, if the language is ambiguous, as it most often is, the arbitrator must interpret the provision in question. By interpreting contract language, arbitrators are often sources of future contract language. CBAs can be drafted with general language to be flexible. Sometimes the party at the bargaining table are purposely vague in some areas to reach agreement in others. And at other times, simply because of the size and complexity of the agreement, inconsistent provisions are a source of contention after the contract is signed. Arbitrators, therefore, are called on to resolve disputes arising from the contract language. So there are times where if there is clear and unambiguous language, and when there is, the arbitrator is guided by basic contract interpretation provisions and principles, which are derived from contract law, such as honoring the intent of the parties, interpreting the agreement as a whole, giving effect to all terms of the agreement, give undefined terms reasonable definitions, and avoid absurd results by considering reason and equity. And so here again we talk about the basic contract principles that the arbitrator is bound to honor if they are actually interpreting clear and unambiguous language in an agreement. And so then by following these rules, an arbitrator crafts an award that often includes an interpretation of a CBA. To some extent, the arbitrator's award is interpreting contract language becomes a part of the contract. So a prior arbitration award that contains a well-reasoned opinion and involves the same parties, the same contract, and the same issues is entitled to great weight in subsequent arbitration. This creates a disincentive, right, for a party dissatisfied with the outcome of arbitration from repeating the same issue before another arbitrator in the hopes of getting a different result. One source of arbitration panels is the Federal Mediation and Conciliation Services Office of the Arbitration Services, or OAS, and their responsibilities include that they maintain a roster of arbitrators qualified to hear and decide labor questions and labor management disputes. They provide the parties involved in CBAs with a list of experienced panels of arbitrators, and they appoint arbitrators following their selection by the involved parties. And so this was the tribunal we talked about earlier. The OAS maintains a roster of about 1,600 private arbitrators, and the maintenance of this roster requires the establishment of and adherence to high standards of qualification. When we talk about the qualifications of an arbitrator, we know that arbitrators are not required to have any specific education or technical training unless they're specified in the CBA. But the qualifications of the arbitrator are obviously key to a successful system. The rigid qualifications are required, it may become very difficult to find an available arbitrator. And so because of this, there are various characteristics which include experience, education, occupation, visibility, which are identified as affecting arbitrator selection. Obviously, both management and labor prefer arbitrators with specific attributes. In addition to the demographic variables, other variables affect arbitrator selection include visibility, such as public speaking and professional association membership, and past arbitration decisions. So, in addition to the visibility, a 2000 study of arbitrator behaviors found that arbitrators who use more procedural justice methods, that is, processes and procedures used during hearing, are perceived to be fairer by the participants. In addition, those who use more interactional justice methods, that is, treat the participants with respect, candor, and a lack of prejudice, are more acceptable and likely to be chosen for future cases. And obviously, there are some general characteristics that are important for an arbitrator, such as impartiality. So no one obviously can be absolutely free from bias or prejudice, but the arbitrator is expected to divest himself or herself from personal inclinations during an arbitration, even though he or she decides cases according to his or her own judgment. Arbitrators are expected to be of the highest integrity. Both parties can review the backgrounds and affiliations of prospective arbitrators, and those include the personal, financial, or business interest in the affairs of either party. A labor management arbitrator should have a broad background of social and economic experience. Maturity of judgment and a quick analytical mind are also necessary. And then labor and management arbitrators are often lawyers. Legal training may help an arbitrator to be objective and to analyze and evaluate facts without personal bias. However, not all lawyers make good arbitrators, nor are all good arbitrators lawyers. And so up until now, we've really discussed the role of an arbitrator as if we had one single person arbitrating a grievance. There can also be situations where multiple arbitrators are needed. And in that case, we establish a tripartite arbitration board, which usually has one or more members which are selected by management, an equal number of members selected by labor, and a neutral member who serves as the chairperson. The labor and management members obviously act as partisans or advocates for their respective sides, and in essence, the neutral chairperson becomes a single arbitrator. The panel chair plays a unique role in the arbitration process since it's their duty to keep the other arbitrators informed about all aspects of the case so they can make informed decisions. So tripartite boards sometimes don't reach decisions unanimously. Collective bargaining agreements therefore often stipulate that a majority award of the board is final and binding. Some agreements may even give the neutral member the sole right and responsibility for making the final decision. And so an advantage of this tripartite board approach rather than the single arbitrator is to provide a neutral member with valuable advice and assistance from the partisan members. Each party may be able to give the neutral arbitrator a more realistic and informed picture of the issues involved than may be given by a formal presentation of the issues. The disadvantage, of course, of this board is the additional time and expense involved. And so now we'll talk some about determining arbitrability. That's a hard word to say. But the basic concept of arbitrability suggests that some disputes and conflicts are not subject to arbitration. The power to determine whether arbitration is proper, the breadth of the contractual issues, and whether any other issues limit the ability of an arbitrator to resolve a dispute is what we call arbitrability. And it involves the challenge of whether a disputed issue is subject to arbitration under the terms of the contract. The courts may be involved with arbitrability in one of three ways. The party challenging arbitrability may seek a temporary judgment or injunction or stay of arbitration pending determination of arbitrability. The party demanding arbitration may seek a court order compelling the other party to arbitrate when the applicable law upholds agreements to arbitrate future disputes. The later party then raises the issue of arbitrability. And then finally, the issue of arbitrability may be considered when an award is taken to court for review or enforcement unless the parties have clearly vested the arbitrator with exclusive and final right of determining arbitrability, or unless the right to challenge arbitrability is held by the court to have been likewise waived under the circumstances of the case. What we find, though, in general, is that the arbitrator may rule on the question of arbitrability. The ruling is not subject to reversal by the courts as long as the arbitrator is applying the contract and acting within the scope of his or her authority. We also have this issue of double jeopardy. And so double jeopardy is a concept involved or borrowed from criminal law for the principle that a person cannot be punished twice for the same offense based on the same conduct. And so example of this is that a bus driver departed from a scheduled stop 5 minutes early and was given a 6-day suspension. So he was scheduled to stay somewhere for 5 minutes longer than when he stayed, and the punishment for that was a 6-day suspension. He accepted the suspension and returned to work afterwards. About a week after he returned to his route, he was informed that because of his history of running ahead of schedule and deviating from his route, he was terminated for his record of numerous offenses. The employer's discipline code included several infractions, including running ahead of schedule, which could result in termination after 4 offenses in a period of the year. The driver's offense was his 4th within a year. The union, however, grieved the driver's termination under this principle of double jeopardy, arguing that his 6th 6-day suspension which he served was the disciplinary action decided by management for the last expense or offense, and the termination decision was a second disciplinary action for the same offense and therefore amounted to double jeopardy or 2 penalties for the same offense. The arbitrator pointed out that the union did not contest the fact that the driver committed a code violation or that the employer had the right to discipline the driver, and that the disciplinary action chosen could have been termination because it was his 4th offense within a year. However, the union did contest management's decision to impart a second disciplinary action for the same offense. And so now let's talk about the actual hearing procedures. So the arbitrator decides what the date of the hearing is after he consults or she consults with both sides of the grievance process. And so then the arbitration of the grievance normally follows these steps. There's an opening statement by the initiating party. There is an opening statement by the other side. The presentation of evidence, witnesses and arguments by the initiating parties, and then a cross-examination by the other side, and then the presentation of evidence, witnesses, and arguments by the defense. And so you can see from this process it's very much like a courtroom trial, right, thus far. And so once the defense has presented the evidence and witnesses and arguments, a cross-examination by the initiating party can happen, a summation by the initiating party, which could be optional, a summation by the other side, which could be optional, and then there's the filing of the briefs, and then there's the arbitrator's award. And so obviously with each of those steps there are certain best practices and commonly accepted practices. So for instance, the opening statement, that lays the groundwork for the testimony of witnesses, and it helps the arbitrator understand the relevance of oral and written evidence. It should clearly identify the issue, it should indicate what's to be proved, and it should specify the relief sought. There are certain rules of evidence with respect to the presentation of evidences, right? And these are now, in arbitration, these strict rules of evidence are not usually observed unless they are expressly required by the parties. In general, any pertinent information or testimony is acceptable as evidence if it helps the arbitrator understand and decide the issue. We also talk about assessing the credibility of witnesses, right? And the arbitrator has to keep in mind that the most confident witnesses are not necessarily the most accurate. Demeanor alone cannot reveal that a witness is lying. Biases because of whether their gender, race, or ethnicity, stereotyping should be eliminated, and the occupation or social class of the witness does not guarantee veracity. And then we go on to talk about some of the other best practices and considerations around presenting documents, examination of witnesses, the summation, and then the arbitrator's award. Once a grievance has reached the point of arbitration, both parties have gone through several steps of discussions and negotiations to resolve the issues. The issues disputed by the parties usually have been well defined by the time the case reaches arbitration. And so, in order to prepare for arbitration, the American Arbitration Association recommends these steps in a hearing preparation. So studying the grievance statement and reviewing its history, examining the initiating grievance paper. It might be found, for instance, that although the original grievance contains many elements, the arbitrator under the contract is restricted to resolving only certain aspects. Reviewing the CBAs from beginning to end, assembling the documents and papers at the hearing. If you think that the arbitrator should visit the plant or job site for on-the-spot investigation, make plans in advance. And the arbitrator under those circumstances should be accompanied by both representatives of parties. There should be an interview of all witnesses, and they should certainly understand the whole case and particularly the importance of their own testimony. We would also want to make a written summary of each proposed witness's testimonies, which becomes useful as a checklist at the hearing to make sure nothing is overlooked. We want to study the other side of the case also and be prepared to answer the opposing evidence and arguments. You want to discuss your outline of the case with others in the organization because their viewpoint often discloses weaknesses or previously overlooked details. And then finally, we want to read as many argument articles and published awards as you can on the general subject matter in the dispute. And so even though those decisions have no binding present value, they may help clarify the thinking of parties and arbitrators alike. What we see here is an excerpt of from Table 12-2 on arbitration issues on page 452 in the text. And we see some of the issues that have gone to arbitration with respect to seniority. And so there are issues such as promotion and upgrading, layoff, bumping, and recall, other seniority issues, working conditions, discrimination, management rights, scheduling of work, and work assignments. So again, these are just some illustrations of the multiple different issues that come up under the subheading of seniority that could make it to arbitration. Under the issue of economic rates and pay raises, we see, or pay issues, we see issues such as wage issues and overtime pay. With wage issues being one of the largest issues that get to arbitration of all the issues involved. And again, I reference Table 12-2 on page 452 and 453 of the text. Additionally, we see items like health and welfare, pensions, and other fringe costs under fringe benefit issues. And then we see discharge and disciplinary issues in general being another subtopic that make it to arbitration. We note technical issues such as being more procedural in nature, such as job postings and biddings, job evaluations, job classifications. We talk about the scope of agreement. We talk about, we're talking about items like subcontracting and jurisdictional disputes. So the most common issue focuses on just cause, which is really a critical, although vague, concept in labor relations. And so just cause refers to the sufficient or proper reason for which management has the right to discipline or discharge employees. As we know, most collective bargaining agreements provide that management has the right to discipline or discharge employees for just cause. In employee discipline and discharge cases, arbitrators commonly apply this idea of a just cause standard in deciding the case. Although particular facts and circumstances of each case are important for the arbitrator to determine if management acted fairly, many arbitrators apply the 7 tests of just cause for discipline, which were developed by arbitrator Ralph Coven in deciding a case. Adequate warning, so is the employee given adequate oral or printed warning as to the consequences of his conduct? Prior investigation, so did management investigate the case before administering the discipline? Evidence, did the investigation produce substantial evidence or proof of guilt? It's not required that the evidence be conclusive or beyond reasonable doubt, except when the misconduct is of criminal nature, that it seriously impairs the chances for future employment of the person accused of wrongdoing. Equal treatment, were all employees judged by the same standards with rules applied equally. Reasonable penalty. Was the penalty reasonably related to the seriousness of the offense and the past record of the employee? The level of the offense should be related to the level of the penalty, and the employee's past record should be taken under consideration. Rule of reason. Was the rule or order reasonably related to evident, efficient, and safe operations? And then internal consistency. So was management enforcement of the rule or procedure consistent? The company should not selectively enforce codes of conduct against certain employees. Enforcement should be fair and objective. And so as we have in prior cases, now we want to talk a few minutes about arbitration in the public sector. And you recall, we talked about interest arbitration, the 2 different types of arbitration, interest arbitration or rights and grievance arbitration. Interest arbitration in the private sector is generally taken in order to prevent or end a strike. What we talked about mostly in the private sector was the idea of grievance arbitration, but In the public sector, interest arbitration is often compulsory and it's required by law, which echoes the rationale of preventing strikes that harm the public interest. Right? So at least 20 states and the federal government deny government employees the right to strike and instead require interest arbitration. These compulsory arbitration laws are especially prevalent among occupations deemed essential, such as those of firefighters, police officers, and prison guards. Legislation that allows public sector collective bargaining but prohibits strikes often details the procedures available to resolve an impasse. As with the private sector, the mediator has no independent authority but uses acquired skill to bring the parties back together. Rights arbitration in the public sector is treated much like the private sector. And so if a public agency agrees to arbitrate employment issues using the just cause standard under rights arbitration, the arbitrator generally has the authority to reinstate a public employee if that standard is violated. However, courts have overturned an arbitrator's decision to reinstate an employee because the arbitrator felt the discipline was too severe. And finally, we note that in the public sector, with respect to rights arbitration, the authority of the arbitrator is limited by the terms and conditions of the collective bargaining agreement. And so in summary, we see that the arbitration process has been developed and refined over many years. The selection of the arbitrator or the board of arbitrators is generally specified in the labor agreement. However, the hearing procedure, which is not bound by legal precedent, is quite flexible and subject to the arbitrator's discretion. And so I hope that this has helped you understand the arbitration process. And please go back and read the text closely. And when you're completed that, don't let this discussion substitute for that. And when you finish that, then let's move on to the discussion forums and the assignments. And thanks for your attention.